Case 27, El Al Israel Airlines versus Tsui Yuan Tseng. We find ourselves at the Supreme Court of the United States. Facts. Before plaintiff or respondent Tseng boarded an El Al Israel Airlines flight from New York to Tel Aviv, El Al subjected her to an intrusive security search. Tseng sued El Al for damages in a New York state court, asserting a state law personal injury claim for, inter alia, assault and false imprisonment, but alleging no bodily injury. El Al removed the case to the federal district court, which dismissed the claim based on the treaty popularly known as the Warsaw Convention. Key convention provisions declare that the treaty applies to all international transportation of persons, baggage, or goods performed by aircraft for hire. The chapter describes 3 areas of air carrier liability: bodily injuries suffered as a result of an accident on board the aircraft or in the course of any of the operations of embarking or disembarking, baggage or goods destruction, loss or damage, and damage caused by delay, and instruct that cases covered under Article 17 can only be brought subject to the conditions and limits set out in the Convention. Tseng's claim was not compensable under Article 17, the district court stated, because Tseng suffered no bodily injury as a result of the search, and the Convention does not permit recovery for solely psychic or psychosomatic injury. That court further concluded that Tseng could not pursue her claim alternatively under New York tort law because Article 24 shields the carrier from liability for personal injuries not compensable under Article 17. Reversing in relevant part, the Second Circuit concluded first that no accident within Article 17's compass had occurred. In that court's view, the Convention drafters did not aim to impose close to absolute liability for an individual's personal reaction to routine operating procedures, which, although inconvenient and embarrassing, are the price passengers pay for airline safety. The court next concluded that the Convention does not shield the same routine operating procedures from assessment under the diverse laws of signatory nations, and in the case of the U.S., states within one nation, governing assault and false imprisonment. Article 24, the court said, precludes resort to local law only where the incident is covered by Article 17. That is, where there has been an accident either on the plane or while embarking or disembarking, which led to bodily injury. The court found support in the drafting history of the Convention, which it construed to indicate that national law was intended to provide the passenger's remedy where the Convention did not expressly apply. In rejecting the argument that allowance of state law claims when the Convention does not permit recovery would contravene the treaty's goal of uniformity, the Second Circuit read Zickerman to instruct specifically that the Convention expresses no compelling interest in uniformity that would warrant supplanting an otherwise applicable body of law. So what's the issue before the Supreme Court? Whether the Warsaw Convention precludes a passenger from maintaining an action for personal injury damages under local law when her claim does not satisfy the conditions for liability under the Convention. The holding. The Warsaw Convention precludes a passenger from maintaining an action for personal injury damages under local law when her claim does not satisfy the conditions for liability under the Convention. Reasoning. The cardinal purpose of the Warsaw Convention is to achieve uniformity of rules governing claims arising from international air transportation. The Convention signatories in the treaty's preamble specifically recognized the advantage of regulating in a uniform manner the conditions of the liability of the carrier. To provide the desired uniformity, Chapter 3 of the Convention sets out an array of liability rules which the treaty declares apply to all international transportation of persons, baggage, or goods performed by aircraft. A complementary purpose of the Convention is to accommodate or balance the interests of passengers seeking recovery for personal injuries and the interests of air carriers seeking to limit potential liability. While affording passengers many rights, the Warsaw Convention is protective of carriers insofar as it limits the passengers' rights. This makes sense given the timing of the law enacted when airlines were new. The court held that the Warsaw Convention precludes a passenger from maintaining an action for personal injury damages under local law when her claim does not satisfy the conditions for liability under the convention. What this means is that a passenger traveling internationally is limited to the terms of the convention, regardless of what state law says on the matter, and including the scenario where the passenger has no remedy under the convention.